So the Copyright Amendment Bill and the Performance Protection Amendment Bill have been referred to the Constitutional Court by President Cyril Ramaphosa. The draft laws were approved by both houses of Parliament on the 29th of February this year. There has been mixed reaction from stakeholders about the signing of the bill. The chairperson of the Copyright Coalition of South Africa, Chola Mahamate, is now joining us live from Poland. Chola, very good morning to you. Thank you so much for making time for us. Last month, we were having the discussion around the deadline for the bills to actually be enacted. And now the conversation is the president referring the bills now to the Constitutional Court, the very Constitutional Court that had also said that there needs to be finality around this matter. I see in the statement the president, in explaining this decision, say that the Constitution allows that if the president still has concerns after Parliament has reconsidered a bill, the president can refer it to the Constitutional Court. Have you had sight of what the president's concerns are?
So this has been a very long process. It's over 10 years around these bills. And throughout the process, a number of concerns have been raised, including constitutional concerns. And in 2020, actually, the president referred the bill back to Parliament when initially first on his desk because there were serious constitutional concerns that he had. One of them being that the incorrect process for consultation regarding legislation for these bills was not followed. Another one being that the provisions in the bills did not comply with international treaties, and he raised about six issues that he wanted Parliament to deal with. One of the things that Parliament did deal with is that they then went through another process of consultation, which now involved the provinces, because this did not happen before. And this was a serious issue. And with a bill of this nature, which impacts trade, you needed to have consulted in the provinces, and that did not happen initially. And this is what then Parliament undertook to do last year, which they did. And in the process, and if you look at the wording of the bill now, it really has not addressed sufficiently even the constitutional issues that are in the bills. There are also other issues which are not necessarily constitutional that are still in the bills that would gravely impact the cultural and creative industries as a whole, and would really diminish the economic contribution that the cultural and creative industries have. So those issues still need to be looked at by the Constitutional Court, and we did raise to the president, even after the bills were passed through the National Assembly, that the issues that we have been raising, the constitutional and other issues that we have been raising for years, are still situated within these draft bills, and they would be disastrous should he sign. And we have been advocating for him not to sign these bills and to actually refer them to the Constitutional Court, and I'm very encouraged that that's the decision that he has made.
Yeah. So when it comes to looking at international treaties, what exactly are those issues that have been raised? I see one of the points that is also highlighted here is that with some foreign companies who are working in the industry in South Africa, they have some concerns around, for instance, a fine of around 10% of annual turnover if a part of the legislation is not being adhered to.
So from that perspective, so the issues with these bills is that it affects the creative and cultural industries across the board. So there's an impact for music that is detrimental, an impact for the audiovisual sector, which is detrimental, an impact for the book publishing and book sector, which is detrimental, animation, and so on and so forth. So there are problems across the board. And the provisions that you're raising regarding the fines is that there are now some very onerous reporting provisions within the bills that would make it difficult, for instance, for production houses, even small production houses who are struggling in this country, not just international companies would be impacted, to meet those obligations. And then should they not do so, they would be met with extremely hefty fines. We do agree that they should be reporting. It's important so that you understand how content is being used, and therefore how creators of content should be paid. But the manner in which you do it should make sense and should be fit for purpose. So that's one of the major issues that have been raised. There are numerous others. There's the issues around what we call exceptions to copyright. So in normal circumstances, when you use somebody's work, use someone's song, use someone's book for whatever purpose, they There are rules within which you can do so, but there are also what we call exceptions to those rules, where you don't necessarily have to pay a fee for the use of that work, and those are clearly defined in the current legislation and meet what we call a 3-step test, which are in the Berne Convention and TRIPS as well, that define under what circumstances you can utilize those works. And one of the major steps is that you cannot unduly prejudice the creator of the work. You must properly, compensate them for that. And now this bill has introduced very, very broad exceptions. They've introduced the concept of fair use, which essentially means free use of works. So creators of content will not be paid. And these exceptions, we argue, do not meet that 3-step test that's set out in international treaties.
Yeah, well, as the coalition, are you opposed to the aspect of the bill that says that actors and performers must be paid royalties when there is a resale of a production? Because I remember with the South African actors, the South African Guild of Actors, they have said that, listen, push through with the bill because currently it is affecting us. Are you opposed to that aspect?
So remember, Aldrin, there are 2 bills here, right, that have been referred. The Copyright Amendment Bill and the Performance Protection Amendment Bill. The Copyright Amendment Bill deals with the creation of the works and the protections that are required for the creators of the works. So those who write books, those who write or compose music. The Performance Protection Amendment Bill deals, and I'm speaking very broadly here because it's also quite a technical issue, deals with those who perform the works created by the creators. Now, unfortunately, performers of works have not been properly compensated, and that is a serious issue. And we support the proper remuneration of the performers of the works. What the issue is here, and it's very unfortunate, is that the 2 bills have been pitted against each other because they have been linked. So they are cross-references to each of the bills in each one. So they are joined at the hip. But really, their relationship is that of mother and child. And if you have a problematic copyright amendment bill, you will not see a situation where the performers will get paid, because if creators of works are not being remunerated and there's no money flowing through that value chain, then performers of works will not be remunerated. So in order for that to happen appropriately, you need to have legislation that is fit for purpose, that works together. And you need to think of the Copyright Amendment Bill as the mother and the Performance Protection Amendment Bill as the child. If you kill the mother, you kill the child. And that is the issue in contention.
Yeah. I wonder if it's possible then, looking at how the president dealt with the Bella bill, where he suspended some of the clauses and still enacted the bill, that perhaps maybe such an approach could work, or is it too complicated, considering also the analogy that you make here of mother and child?
So look, those are the options that we're looking at. We had previously advocated that the bills be delinked, so that you deal with the Performance Protection Amendment Bill separately. It's not a perfect bill, but if you can deal with certain provisions, it's something that could be pushed through. But that's not necessarily, like you're saying, it's a very technical issue now. It's too late for that to happen. From our perspective, we think that we must just have legislation that's appropriately drafted and fit for purpose for South Africa, and still advocate for the fair remuneration of performers, and also advocate for the rights of the visually impaired to be taken care of.
Yeah. Would it be applying retrospectively as well, specifically for work that is already out there and conversations that are currently underway around the resale of some productions?
No, there would not be. And that was one of the issues that was raised initially, is the retrospective application. There wouldn't be retrospective application.
There wouldn't be retrospective application. Okay, so what would you like to see come out of the Constitutional Court when they deliberate over this matter that the president has brought before them?
We would like them to take the position that indeed the issues that have been raised about the constitutionality of the bills are correct, and make an order in that regard, because and these are the submissions that we will now be making as well to the Constitutional Court, is that this bill, particularly the Copyright Amendment Bill, would be disastrous for the cultural and creative industries in South Africa. It would impact the livelihoods of creators in South Africa. It would impact the value chain in each of the different sectors within the culture and creative industries. It would impact trade. It would impact things like South Africa's trade relations with the EU and the US from a AGOA perspective. The damage would just be terrible.
Okay, the damage will be terrible. Let's see how this is going to play out, because now it is back with the Constitutional Court. Thank you so much for your time, Chola Mahamadede, who is with the Copyright Coalition of South Africa. And as I've indicated, that the South African Guild of Actors have been pushing and saying that the president must sign these bills as soon as possible. But now the matter is going before the Constitutional Court. We're going to take a quick